Hello and welcome back. My name is Dr. Craig Selinger, a chiropractic physician, and this is the Injury Podcast. So today we have a great episode. I want to just explain some things. A lot of people out there listening might have been injured or know somebody that's been injured. And sometimes a person gets injured and they don't recover or they can't work again. So in my particular office, we've seen many people that has happened to over the years. And we've seen people that have applied for disability benefits because they're not able to work anymore. I wanted to do a show about disability insurance and all the different areas because it's complicated and a lot of people don't understand it. And today we have a special guest, a South Florida attorney that specializes in Social Security disability law or disability law. And his name is Joseph Bendel. Welcome, Joseph, to the show.
Thank you very much for having me, Craig.
Yeah. Before we jump in, I just want to tell everybody a disclaimer. We got to get the legalese out of the way here. So this show is for educational purposes only. It does not constitute the practice of medicine, chiropractic, physical therapy, or law. We do have an attorney on, and I'm a chiropractor. This also does not represent any kind of a relationship or a form of professional relationship between myself or between the attorney that we have on. This is for educational purposes only. So, with that being said, we're going to jump in. First, Joseph, what is Social Security disability? And I know there are some different terms. There's SSI, SSDI. Well, let's shed a little light on this.
Okay, so let's start with SSDI, the first thing you mentioned. That's Social Security Disability Insurance. Every month when you work, you get deducted from your paycheck a certain amount for Social Security. You see it come out. Where does it go? That becomes your payment for Social Security Disability Insurance. It's also your payment for retirement benefits. SSDI, Social Security Disability Insurance, is you getting your Social Security retirement benefits early based on disability. So usually Social Security kicks in for people, whatever it's going to be, 63, 65, 70 if you want to wait. But SSDI and a claim for disability gets you those benefits right away. Let's talk about what SSI is, and they're different categories. Social Security Disability Insurance we paid for. We paid into the system, we get back when we get disabled. SSI is different. It is needs-based. If a person has less than $2,000 or $3,000 in assets total and makes, the numbers change every year, but you can look them up, but and makes around less than $1,500 a month, and they're disabled, then they have available to them SSI, okay? SSDI, you can have retirement funds, you can have savings, and you can still be entitled to your SSDI, whether it's beforehand based on a disability or eventually when you take them as a retirement benefit.
Great. So, one is more we're paying into the system. We've paid this in our over the course of our life working, and the other one is more needs based.
That's right.
Correct.
That's right.
Okay. What are some types of conditions that people that are applying for disability insurance and benefits? What are some of those conditions? And is there a guide? Is there a guide or of all these different conditions?
Yeah, people apply for any condition that disables them, and there could be any number of reasons that a person could be disabled. One of the ways we look to whether someone is going to be eligible for their disability benefits is that the Social Security puts out what's called the Blue Book, and it's an appendix to the regulations. And in that Blue Book, I don't think it's officially called that, but it's called that among practitioners, and people generally know what we're talking about when we talk about the Blue Book. And it lists just about every physical and mental malady you can have, from musculoskeletal issues to mental health issues to intellectual disorders, whatever you have. It's all listed there, and in there are specific requirements for each one of those disabilities. One of the really harsh things that comes up in the Blue Book, that being blind in one eye is not enough to be disabled. There's still, the Social Security thinks there are still jobs that you can do even being blind in one eye. So the Blue Book can be kind of harsh and rigid in that way, but it does list the requirements. So if you did have a vision problem that completely prevented you from working, then yeah, that's a disability. But as I said, even one eye, it's still going to consider that person able to work.
Right. Something else I wanted to ask is a lot of people out there might be working and doing a job, maybe it's sitting, and let's say it's not a very physical job. If somebody has let's say a serious knee condition where they can't stand that long, can they likely get disability, or does it have to somehow affect their injury, have to affect, or their condition affect their job directly?
So the question that the Social Security rules ask is, can this person engage in substantial gainful activity? Okay? And what that means can be different for different people. If someone has done nothing other than serve tables until they're 60 years old and has limited education, Social Security is going to view that person as having a limited ability to retrain and may not be able to engage in that substantial gainful activity, which is a job, and may not view that person able to retrain to go into another job. So if they're disabled from being able to serve tables, then they're completely disabled. However, younger people who may have the ability to retrain, Social Security may expect you to go out and take a course, a vocational program, to go out and get retrained and get yourself back into the workforce even with an injury.
Okay. So there, if your injury does not affect your job, then there's a high likelihood that you wouldn't be able to get benefits, or there would be a challenge to that.
If you're still working, you don't qualify.
Okay.
And that's right there on the checklist. If you're still engaging in substantial gainful activity, which, the number changes every year, if it's 1,550 now or 1,600, if you're making that much a month, the Social Security will point to you and say you can work. Right. And it's very clear that you can work because you are working and you are earning, even though it's not a huge sum and it may represent even partial work or not a full-time job. That's the amount and that's the line that the Social Security draws.
Yeah, because I think in my practice, I've seen some patients, they're in a serious accident and they have injuries, but the type of job they do is not directly, their injury doesn't directly affect their ability to work. They could still work. They do customer service, let's say, and they're answering calls or helping customers with problems. And that is something that, if they're continuing to do, is not affected by their injury, they wouldn't be able to probably qualify to get those benefits. Is there a waiting period? So somebody gets into an accident, let's say a month ago, they have an injury. Is there typically a waiting period, 90 days, 60 days, 6 months, before somebody could try to get Social Security disability benefits?
The rule for the duration of the disability is that it lasts or is expected to last 1 year. That's what constitutes a disability. So depending on the accident, depending on the injuries, are they going to, is this something they can bounce back from? Is this going to be a short stay in the hospital and a little bit of treatment and they're going to go back to work? or is this going to be something that's a multi-year process, or maybe they'll never recover? So that's the rule, and that's the line that the Social Security looks to.
Okay. What are some mistakes that hurt a disability claim and make it difficult for somebody to get benefits?
One of the really easy things it is to get right is to have ongoing treatment. The failure to treat yourself or the failure to go and see doctors can be fatal to a claim, because if you look at it from the Social Security's perspective, you could heal. Let's say you're in an accident and you haven't gone to a doctor, you have a broken hand, and you say you're disabled. They say, well, you haven't really gotten the treatment, have you? And they could say that about many ailments and injuries. Are you getting treated, and can you make this better through treatment? And some of the problems I see and some of the traps people fall into is that they're seeking money from Social Security to support themselves and pay for that medical care, and they don't have the money to pay for the care and with an ongoing file. So they have this trap where they don't have the money to pay for the doctor, and they don't have the Social Security to come in and cover that cost. So it's a tough situation people find themselves in.
Wow, that's a catch-22. They don't have the money to pay for treatment, but then they need the treatment to justify to being able to file and potentially get the benefits that they really need. Wow. So if they do treat, what have you seen that has been helpful for a client, one of your clients, to get disability benefits, and what things hurt the case in terms of them being able to get disability benefits?
So, what helps, I wish I knew. I wish I knew, because I do it every time. There are thousands of Social Security agents who handle each case differently according to the way they were trained and the way they want to handle their cases. There's also many, many administrative law judges. Those are the Social Security judges that handle these cases later on, and they have a great variety of approval ratings. You have from 50% of approval to 90% denial. So what a big factor is always going to be in your case, and you can't control, is which agent's desk this lands on and which judge is going to get your case.
Okay.
But there is, in the application process, I think one of the things people think is going to get them benefits is to give Social Security a long list of everything that they've gone through in the past 5 years. And I don't think that's a winning strategy. A winning strategy is finding the condition that disables you, that gets you benefits. If you throw 10 conditions at Social Security, they're just going to look at these and say, well, none of them is clearly disabling, so none of them gets you your benefits. You need to find that one disabling condition, whatever it is, and argue that effectively.
Right. And there's so many different conditions that can be that a person can have. In my office, sometimes patients have multiple extremity conditions. They have spine conditions, but also there might be a person that has mental illness. So those are conditions somebody can have as well. So if somebody has mental illness, would they be able to file for disability?
Absolutely. Mental illnesses are part of the Blue Book, and there's various federal authorities that state that mental illness is treated on the same tier as physical illnesses, especially in the Americans with Disabilities Act. It's explicit that mental disabilities are treated on the same tier as physical disabilities.
Okay, wow, that's great to know. So a Social Security disability attorney will be able to get the medical files from the doctors that treated the patient and be able to set up a strategy for their client and present and go through the application process to help them get benefits, correct?
So The initial application process is something that I want to help with and I answer questions on it, but I shy away from representing people at that stage because I don't think a phone call or half a phone call entitles me to a fee or a chunk of the back pay that a person may get. So, from the application stage, what does it look like? It's clicking through SSA.gov for 45 minutes to an hour and a half, writing down your medications, writing down your doctors, where you've been treated, and all that stuff. So I let people do that on their own. And where I really become useful is for the hearing stage. So the procedure goes initial application, first denial, then you ask for reconsideration, and then if you get denied at that stage again, you can go up to a judge. The judge is really where I have something to do, which is where I get the opportunity to present people's cases in the best light possible. The other stages, to me, they're a black box. I don't, reconsideration, it's not that common that people win on reconsideration. So again, I can help people click through and we can put our best foot forward and maybe suggest to Social Security, hey, look at this doctor's report, look at this page. It seems like they meet under that, but we really don't know. I don't really know who the agents are or what they're doing. The judge is the real opportunity to get your case heard by a real person who has authority to make a decision on your case.
Okay. So the client would go and apply and go through the application process, and then later in you can assist with those other avenues.
Yeah.
Okay, great. What medical records and functional limitations do you typically see that maybe are missing? Is there anything that somebody out there, a patient out there, can ask their doctor or make sure their file includes functional limitations? So, for example, in my office, we go through a daily activity, functional activities of daily living assessment form with people, and we get an understanding of what the patient can and can't do. This serves, one, to show progress. It also allows me to teach them and educate them how to live properly or do these activities of daily living without re-injuring themselves. What have you seen that's helpful? Is there anything that someone out there that is starting this process or thinking about it, they need to be able to communicate with their doctor provider that they're going to?
So there are some forms that the Social Security puts out to be able to dig into functional limitations of disabilities. One of them is a residual functional capacity. Another one is a mental residual functional capacity that are going to be similar to these types of forms. Sometimes they'll send them out and solicit this information, say, hey, have your doctor fill this out and let us know, where you are according to our standards. And sometimes I'll send it in without being prompted because I know that this person has a mental condition that results in certain limitations, and I want to show them according to their standards, according to their rules on their form, that this meets the standards for disability.
Okay. And they're also going to, I know we've gotten the records request from disability, and we'll send in our information, and I'm sure all their doctors, the patient should put in there, even if they maybe think it's not related, because maybe their primary care doctor has some information that might in some way help their case as well.
What's critical and what's treated as the best evidence for the Social Security Administration is treating physician. So this isn't someone that you walked in and asked for an assessment of a mental condition. The best evidence is going to come from someone who's been treating you for some time.
Great. All right. So I know that we talked a little bit about Social Security disability benefits and so forth, but I know that there's other disability type of benefits, veterans. There's also private insurance, disability insurance benefits as well. Can you shed some light on veterans, what they can do if they're listening to this uh, some tips if they're feeling that they might not be able to do their work anymore?
So I don't deal with the VA, but I have dealt with veterans, and there's kind of two challenges that they face. Um, One is that the VA rating, sometimes people are rated 90% or 100%. The VA rating doesn't immediately carry over to Social Security as much as we'd like it to. There's a specific regulation that says that they're not going to blindly accept the determinations of other agencies. However, Social Security will still always look at the underlying medical evidence. So one challenge that already veterans have is that they went out and got themselves determined disabled. They submitted all their medical records and they got their rating, and they're kind of back to square one now. Now someone, they get a letter back, they get a denial back from Social Security after applying saying, hey, you're not disabled. So, that's one challenge they go through. And another thing that really applies to everyone and that veterans are also going to go through, I'm sure you've seen too, is that sometimes injuries take time to manifest. And if, some people get injured, there could be a traumatic event and they get right back to work, and they get right back to work for a year until they realize, hey, I'm not really sleeping, or hey, something's not right. That can be a challenge because someone looking at the file critically and someone looking at it for an eye to deny is going to say, look, this guy got injured and he went right back to work. Look at how he's okay. But you as a medical professional, and I've seen people go through injury and go through recovery. It's just not as straightforward as that.
Wow. And for people that have private disability insurance and they've had an accident or they have a chronic disease or illness and now they can't do their particular job, what differences would you say there are between Social Security disability and private disability insurance when people are trying to apply for those benefits?
Well, the big difference is that private insurance you have to purchase beforehand.
Hmm.
Social Security you're going to get just by your employer paying your taxes. Um, the key question that both of these policies and both of these insurances are going to face is, are you clearly disabled? Because people can fall somewhere on the line. People might be able to go out for a walk and enjoy standing up without pain for 5 or 10 minutes around their house, but that doesn't mean that they can function in an office environment. So both of these entities, Social Security and your private insurer, are all looking at it critically, and it's pretty awful to be disabled and to get a letter either from Social Security or your private insurer that says, nah, we don't think you're disabled enough. This isn't really it. And people have been struggling with this for years. They know that they can't go back to work. They know they're disabled, and that's a challenge unto itself. And to have a private insurer or Social Security come up and say, nah, it's not really happening, is a huge slap, and it's a huge deal. What's similar about those is that you have the opportunity to appeal. Most private insurance plans should have the right to appeal, and Social Security has its pathways for appealing through the different stages we discussed.
What are, in your experience, the most common reasons why people get denied disability benefits?
So there's some lines that you can see in Social Security correspondence that are cut and paste one from the last one. And one of those lines, I can't quote it verbatim, but says something to the effect of, we can see that you have illnesses, but we don't think that these illnesses result in you being unable to work, so go back to work. Well, it doesn't say, so go back to work, but it says, we don't think that these illnesses are really disabling you.
And you, in that appeal process, you'll go and make an argument that they do, or that and show that they do.
As an attorney, my job is to present people's case in the best light possible. So I gather the medical evidence. Sometimes it's something I have to do myself. Social Security, you got the requests. They make all the medical record requests, and then before the hearing, I can access that record and I can go into the record and show, look, Dr. So-and-so said on such and such they're diagnosed with this and they have this functional limitation, and now you can see it through the entire record. That's good evidence. The key thing that makes Social Security really different from the rest of the practice of law is that when you go in front of a regular judge, they can consider evidence that they think is relevant, or they may have different evidentiary rules. Social Security, I don't want to say the very only evidence they consider is the medical record, but the only evidence they consider is the medical record. Almost the only evidence they consider is the medical record. So in other cases in civil suit, I'd like to do affidavits. I'd like to say, from my client, from my patient, I can't do this, I can't do that. That isn't something that they consider. I can always put it in front of a judge and say, maybe you think that this is persuasive, but the rules are pretty clear that it comes down to the medical record. So, my job as an attorney is to go through that medical record and find those items, those illnesses, and those diagnoses that are disabling, and put them, reference them, put them in front of the judge, and say, look, this is why this person is disabled.
Okay. Now, does age and educational background play a role whether or not somebody is going to be denied Social Security disability or maybe other disability insurance coverage
So
benefits?
there is an expectation for younger people that if they lose the ability to perform one job, let's say, a person is a server and they, heaven forbid, would lose a leg or lose their ability to move around the restaurant that way. The Social Security does have some expectation of people that they should retrain and find another job. For older people, that expectation diminishes and disappears. But for younger people, especially who've shown, that they can do fine in school, Social Security thinks you can go and retrain and get another job.
Wow. So if you are younger and you have an injury, it might be harder to get benefits because you're able to retrain and pivot and choose another vocation and get retrained. And then if you're older, that expectation is decreased. Wow, I didn't know that.
Yeah, there's a table that Social Security puts out that I don't have memorized, but that's the gist of it. Is that younger you kind of are expected to retrain, and older they relax that requirement.
Wow. And you mentioned before the most important medical records are typically from the treating physician. So some people I know, I've gotten calls in my office where they want me to do a disability evaluation. And we traditionally don't do that. We'll do those if asked, if requested, on our existing patients. But that is something. Is that something that's correct as well?
If you wanted to make your assessment as strong as you could make it, you would see that person more than once, because the judge is going to decide what evidence is relevant and what evidence is persuasive, and it only makes sense that the physician or the medical professional that's been treating that person for some time and knows that person has the best information on that patient.
Okay. Now, when you work with people that have private insurance, disability insurance, are there different definitions of what disability actually constitutes? Because you talked before about Social Security, it being very uniform and consistent. So if somebody has a disability policy, let's say with insurance company A versus insurance company B versus insurance company C, are they all different, or do they have to have a standard type of definition of what constitutes that person being disabled?
One standard that I've seen come across my files that presents a challenge to the client is that for a certain amount of time, they were covered if they were disabled from performing their old job. And then after a certain amount of time, the policy switched and said, we're only going to cover you if you're disabled from any job. So during the time that person was disabled from their old job, they're happy to pay. And then someone in the insurance company woke up and flipped the switch and said, or the time expired in the contract, and said, I think you can retrain for another job. I don't think your disability is disabling from any job, so your benefits are gone.
What does the term own OC mean for private disability insurance companies?
Own OC?
Yeah, like owner occupation. I guess there's terms where if you can't do a specific job, like what you're referring to, versus you can still work. But let's say, for instance, somebody is a dentist and they have a hand injury, and they can't they can't do that particular job as a dentist, but they have the education and they're young and they could work in another field. Maybe they could even go back to school and become an attorney.
Yeah.
So could you shed some light on that a little bit? Is that
the language that I've seen, and it does have applicability in Social Security cases, is work at your job versus work at any job. So what does work at any job mean, right? My professors at the University of Miami School of Law, Health and Elder Law Clinic, now the Health Law Clinic, said that the job that we look to and the question we ask as to whether someone can perform any job is you ask if they can function as a toll booth operator. Okay?
Okay.
Can they sit there and take the change and punch in, work a register, people come and go and they just sit there and take change and make change? Is that something that they can handle? And, for that time, for my office's purposes, if we argue that a person can't be a toll booth operator, then that's someone who cannot work at any job. If they can be a toll booth operator, then they might still have the ability to retrain or go out and find another job that they're able to work at. But if they can't be a toll booth operator, if there's, if someone has to use the bathroom every 5 minutes or what, I don't know if that's a real condition. But if there's something that prevents you from even being a toll booth operator, then that's any job.
Okay? Wow. So, and you handle private disability insurance matters as well, correct?
Yeah.
Okay. All right. Question. Somebody is in an auto accident. Many of the people here listening to this podcast have been or know people that have been in accidents. They've fallen or they've been in a car accident. They get a settlement of, let's just say, $1 million. Okay? $1 million settlement. They are no longer able to work for FedEx or UPS, and they're not able to drive. They still can walk, but, and maybe even be a toll booth operator, possibly. They're 40, 50 years old. Is that person eligible because they got this settlement? Can they still apply for disability?
The requirements for eligibility for Social Security, or one of the key ones, is that you've worked 40 quarters, or about 10 years. After you've met that requirement, you are eligible for Social Security. The question is, can this person engage in substantial gainful activity? Can they go out and have a job? And that's the threshold question for disability. So it could be that they've won their injury case, but let's say they recover and maybe they can do some jobs. It would be great for them. Then that would not be a disability for Social Security purposes. I've had people call in and they're kind of on the edge where they say, I am sick and I have a tough time working, but I'm not really sure if it's enough to call a disability. Maybe I can work, or maybe I just got fired from this job. And I tell people the same thing, that the Social Security payments are an average of $1,600. So it's it's obviously significant and it's something, but most people can make more than that working. The favorable solution and the favorable outcome for people is that they get back to work and that they're able to work and that they're able-bodied. And that's really the goal that everyone has. If they can't, which happens to many people, if they can't, then we go to Social Security and our safety net programs. But the safety net is not really comprehensive. It's not a huge amount, and for some people, is $1,600 a month enough to live on? Probably not. Maybe to contribute to a household or something like that. So even getting the Social Security is not a big windfall. It's not necessarily a big sigh of relief. It's something, and it's something to survive on. But it's most preferable for people to continue working if they can.
Right. And is that so the average payment you would say would be about 1,600 a month, or does it vary if somebody's 55 or versus 35, Is it different or
There's a calculation that exists based on people's prior earnings. In simplicity, if you earned a lot of money during that time that you gained your eligibility for Social Security, your payment will be higher. If you did not earn all that much money, your payment will be lower. And it's a formula that exists for
Right.
Social Security.
So it's based upon how much you've paid into the system in taxes, or your employer has paid in taxes. So somebody that is older would have a more of a payment, just like when people retire, sometimes at a later age, at 70 versus 63 or 62, they might get more. Is it similar to that?
No, I think the look back period for where they determine your income for the purpose of your payment, is a 5 or 10 year period. I believe it's the 5 or 10 year period immediately before you apply, or there may be some averaging in your total income, but that's where it's based on.
Okay. So being that we're in Florida here, we have very high insurance costs. I'm talking about homeowners insurance. I'm talking about car insurance especially. And what I've seen a trend in the last 5 years is many people having accidents, and the person that hit them doesn't have very high limits. So they might only get a very minimal recovery if they were hurt due to somebody else's negligence. And sometimes sometimes in that particular case, these people might not be able to work, and there was a very low recovery settlement on that they were able to get because of the lack of insurance on the side that hit them. So in that particular case, that particular person, again, they were in an auto accident. They were injured. They can't do their regular type of job that they were doing. Maybe they had a very physical job, and they would then be able to apply for disability, and that might be somebody that might benefit more from it because one, they can't work, and two, they didn't get much anyway from the case, and that happens. Do you see that in your practice? People that have had injuries, like a accident, or is it more chronic conditions that you see, like a heart disease or some other mental illness?
No, the Blue Book and the variety of ailments that people can suffer from is thick.
Okay.
There are a lot of reasons that people can have to be disabled, and the person in the accident that you just mentioned that didn't get that payout. I wanted to mention there are certain circumstances where people can get both SSI and SSDI. If they did the work and paid into the system for SSDI, they qualify. If they also don't meet the asset and income tests, which means they have very little to their name and they're not earning very much, you could be eligible for both, which is if someone lost their job and they're disabled, it may be a lifeline.
So, what kind of just ballpark figure that somebody might be able to be entitled to, like a range? What would you say?
I think SSI payments are around $900 a month again, average. But I think that's not based on your income. That's going to be based on
A need.
a number set at the federal level, I believe. Um, but again, if a person has the need for both and can't work, it's available. It exists.
Okay, great. Uh, the other question that I have related to insurance was we also have very high health care premiums in this country. It's skyrocketed. Is when somebody has a disability, do they get Medicare?
I believe um, after you get approved for SSDI, after a year or two, you're automatically eligible for Medicare. There's a wait period. Again, I'm not sure if it's a year or two. You can look it up on Google, but you do get Medicare with Social Security.
Wow. Okay. So that is
And
pretty substantial because people might not be able to afford their health insurance premium, and then even if it's after a period of time, they can get uh, that Medicare type of insurance where they wouldn't have to wait till 67 or I'm sorry, 65 or over to get those benefits.
yeah, I mean, the difficulty is what do you do for those 1 or 2 years? If you have the need and you don't have income and you don't have a job, where does the insurance come from in those 1 or 2 years? It's a gap. There's many gaps in our safety nets and in our social systems that are like that. And you know, I get the calls from people who say, what am I supposed to do for the next year? So it would be nice if it was more comprehensive, but eventually it does kick in.
Okay. And I just want to review real quick for the viewers. When should somebody hire a Social Security disability attorney? At what point would you typically recommend?
I I'm happy to take people after an initial denial or when they're going up in front of a judge. What I really do is go in front of judges and present cases in their best light possible. That's really my core function. On the reconsiderations and on the other files, it's just making sure to communicate with Social Security. If they send a supplemental form, hey, we want we want your doctor to fill out this functional form for your specific illness. My job is making sure that all the paperwork is done on time and we don't miss any deadlines, that we're communicating with Social Security. The real core function of my job is arguing for people at hearings. So I take cases from reconsideration onwards. Initial applications, I help as much as I can, but I just don't think that it adds great value, my opinion or my position at that stage. So once people are after a denial or after a reconsideration, that's when I have a lot to do.
Okay. And if somebody is disabled and they can't work, how do they afford to hire a disability attorney?
So when a person applies for Social Security, it can be months before they're approved. People get what's called back pay, which is they get their benefits from the time they made the application until the time that it was approved. And it's a lump sum, but it's broken up for people. So I get paid out of that lump sum. Usually I take 25% of that lump sum up to a maximum set by regulation currently at $9,200. So there's no Social Security case that exists that I can take more than $9,200 at this phase. The attorney never takes the ongoing benefits. It's the back pay.
Okay. So that's good to know. So for most people that are going to apply for Social Security disability benefits, there is no out-of-pocket upfront cost that they would have to pay you. Is that correct? Or do some charge?
There could be costs on any file, mailings and little things like that, but attorney's fees, my agreements and my contracts are for a percentage of that back pay.
Okay. All right, that's great to know because people might not call an attorney because they might fear they're going to have to come up with $5,000 or a lot of money at that time, and if they can't work, they wouldn't be able to retain, and they would feel they wouldn't be able to retain an attorney. So that's interesting.
There's definitely the perception that I've run into also that the attorney is going to take your benefits forever, and that's just not how it works. It's that back pay that we attach to.
And I'm sure, like that, what what you spoke about before, somebody that is not able to work, that's disabled, uh, unable to work, they already have the stress of not being able to work, not being able to provide. They've had possibly injury or other medical condition, or they might have a mental illness, like what we spoke about. So having an attorney help them navigate this process after the application
Hmm.
is peace of mind, because the stress that goes along with being in that position
Yeah.
is is just something that people can maybe be more confident and positive that there will be something to help them make ends meet.
Mm. The shock and insult of going into a Social Security hearing and someone pointing the finger at you and saying, "Well, you're not really disabled," which is, I mean, vocational experts can show up to Social Security hearings where that's essentially what they argue. You can work at a job. The shock and insult of being told that to your face uh, isn't really conducive to being able to argue your case effectively in front of the judge. It's wild. It's so shocking and upsetting to hear that, even in the mail, to see that we don't really think that you're disabled. To stand face to face with someone who's saying that we don't really think you're disabled. Um, you know, if it was me personally, I wouldn't be able to argue effectively, to put together my words. I would just say, "How dare you?"
People process that as you're calling me a liar,
Yeah.
and they become insulted. Uh, they can't. They don't understand the process. Now they're angry and mad, and they might just give up. And they're really entitled to these benefits, but they just have been called a liar, or that's how they process it. Especially people that are suffering with mental illness, or they might not be able to cope and get through this process without an attorney helping them through this way. So, what should somebody do if they're injured out there? They're listening to this podcast, they've been injured, they can't go to work, they've tried, and they can't work. What would somebody do? A list of things that they should do.
If you believe you're disabled, go ahead and apply. Start the clock, because for a disability claim to work its way through the system can be anywhere from a year plus to 2 years. That's from going from initial application through reconsideration through a hearing. So, my first recommendation is don't wait. Start that clock. If you need to add evidence, if you need to gather other evidence, if you need to go and find a doctor who's going to treat you, go do it. Go do it as soon as you can, but start the clock on that application. Put together the best application you can now.
Now, if somebody applies, let's say today, but they haven't been able to work for a year, does that go back to when they first couldn't work and they don't have any pay stubs and they haven't been working? Is that would they be entitled to back pay from then?
So we're running into one of the really challenging technicalities of disability benefits. So there's something called the recent work test, which means that a person has to have these credits. That means that they paid into Social Security. I think it's within the past 5 years. That can be a problem for people, because if some people, had the support, they became disabled, they stopped working, and then they stop working for 5 years and they don't make their application. Now they don't meet the recent work test and they're not eligible. So that's definitely a big challenge. And remind me what the other thing we're dealing with is.
Yeah, so if somebody applies today, okay, for Social Security
So
disability.
I
And then, but they haven't been able to work for a year. Maybe they weren't aware that they could apply, or they thought they were going to get better, but they haven't been working because they can't deliver packages or lift heavy things or do some function that they weren't able to do, so they haven't been working. Do they get paid for that back pay that before they applied even?
So you can apply for benefits retroactively. That is, you can apply and say that the date that you became disabled was a year or two ago. In practice, I think it's viewed with a lot of scrutiny because you're going and asking the government for much more money or for more money or for your benefits to start on a different date. So there are standards and there can be higher standards for proving that your disability began on a certain date. But if, in the case of a car accident, we'd have records of the date that occurred, hospital records, other good evidence of the date of the disability, so then it might be easier to apply for a prior date for retroactive benefits, but otherwise it can be a challenge.
Okay. What's the number one biggest misconception about disability benefits?
That there's fraud. I've had a lot of calls come into my office, and every one of them are suffering. And when calls come into my office, I believe people. When they say they can't work, I believe people, and it's my job to go into the record and find it. And it's there. It's not that people are making this up. It's not that people are seeking a free ride. And the many calls that I've gotten, I've had one person call and say that I think I should get something I'm not entitled to. Like, I've heard that there's this thing, and I want you to get it for me, which is one out of, I don't want to say hundreds, but in the 75 to 100 to plus area. So that's something that really hurts, I think, the disabled, and it really hurts the community. The idea that people are trying to cheat the government to get a free ride. People are trying to cheat the government for $1,600 a month, and they went through a terrible accident or they have some terrible illness, and that now they're a cheat. I think that's the most damaging thing to the practice and to the people that go through this.
Wow. So we've really shed a light on a lot of information about disability. What I understand now is that if someone's in doubt and they can't work, they should start and apply. And where should they go online to apply for disability?
So ssa.gov is the Social Security's website. It's pretty good. To log in the first time, you may have to do some secondary identity verification, which of course we want on our Social Security benefits. But the website is really pretty good, and you can make an application right there, set aside half an hour to 2 hours, depending on how extensive your medical record is. Click through and fill out boxes. That's the application.
Okay, great. And if somebody wants to get in touch with you, Joseph, please give us your contact information, and we'll include this in the show notes for the podcast. But how can they reach you? What's the best way for them to reach you?
People can reach out. The website that I have, bendel-law.com, has a contact form. I'm on Facebook and Instagram. I believe people can call and message straight through Google. So I'm there to take the calls and to talk to people who are going through this.
Right. And you also work with attorneys too. Do attorneys call you or have questions with clients they might have?
I've had some other attorneys find my website or find my practice and had people who need these kinds of services call me or call and ask if it's okay that they refer people, or call to see if I'm open and I'm still handling these cases. So I have gotten some contact from other attorneys sending cases.
Great. Okay. Well, at this part of the show, we have a ritual where we have superhero tumblers, and we give one of these tumblers to a guest as a comeback symbol. And behind you, we have a bunch of tumblers, and they represent some different areas of resilience and comeback. Of the tumblers, which one speaks to you, or which one do you identify with the most?
I walked in and I had my eye on only one of them, and it's Batman. And, you know, Batman goes out and he fights for justice by breaking femurs and by trampling people's civil rights, however he does. But in the movies, in the Dark Knight movies, you see he has a real adoration for Harvey Dent, which is someone who can go out and in public show his face, stand up to the system, stand up to the oppressors. And Batman, you know, he almost quit the Batman practice because Harvey Dent was doing such a good job. So when I walked in, I saw the Batman, and that was mine.
Awesome. That's great. Well, thank you for being on our podcast. I really appreciate it. We learned a lot about disability, and this is something that affects so many different people. If you have any questions, please contact Joseph Bendel. And thank you for tuning in. Like I say all the time, follow, like, subscribe. See you on the other side.